Hi friends, in this video we are going to deal with the case summary of the latest Supreme Court judgment pronounced now in the area of service law, especially matters involving that after the death of the government servant, a son or daughter adopted by the widow of that deceased government servant cannot be included within the definition of family under Rule 54(14)(b) of the Central Civil Services Pension Rules to claim family pension. To know more about it, please watch this video fully. If it is helpful to you, please like, share and comment, and never forget to subscribe to it, and further click on the bell icon next to the subscribe button. In the important judgment titled Sriram Sridhar Chimurkar versus Union of India and another, pronounced on 17th Jan 2023, after the death of the government employee, his wife adopted appellant. The appellant claimed for family pension, but it was rejected on ground that after the death of the government employee, children adopted by widow would not be entitled to receive family pension as per Rule 54(14)(b) of the Central Civil Services Pension Rules. Allowing his application, Central Administrative Tribunal directed the authorities to consider his claim for family pension by treating him as the adopted son of the deceased government employee as per sections 8 and 12 of the Hindu Adoptions and Maintenance Act. But the Bombay High Court reversed the order passed by the tribunal. Being aggrieved, the present appeal has been filed. The issue posed for consideration is whether a child adopted by a widow of a government servant subsequent to his death would be included within the scope of the definition of family under Rule 54(14)(b) of the CCS pension rules and would therefore be entitled to receive family pension payable under the said rules. The Supreme Court has held that Section 8 of the Hindu Adoptions and Maintenance Act permits a female Hindu who is not a minor or of unsound mind to take a son or daughter in adoption to herself in her own right. The provision requires that a female Hindu who has a husband shall not adopt except with the express consent of her husband. However, no such precondition is applicable in relation to a Hindu widow, a divorced female Hindu, or female Hindu whose husband has, after marriage, finally renounced the world or has been declared by a court of competent jurisdiction to be of unsound mind. Therefore, there exists an unequivocal statutory declaration as to the capacity of a female Hindu, including a widow, to take a son or daughter in adoption in her own right. The said provisions of the Hindu Adoptions and Maintenance Act determine the rights of a son adopted by a Hindu widow only vis-a-vis his adoptive family. Rights and entitlements of an adopted son of a Hindu widow as available in Hindu law as against his adopted family cannot be axiomatically be held to be available to such adopted son as against the government in a case specifically governed by extant pension rules. The provisions of the Hindu Adoptions and Maintenance Act do not lend much assistance in the present case, which does not pertain to the rights of the adoptee, such as the appellant under Hindu law, but to his rights and entitlements under the CCS pension rules. There exists a vital difference between the rights of an adopted son under the Hindu law and his rights to draw family pension, which creates a burden on the public exchequer. It is therefore necessary to determine the rights and entitlements of the appellant having regard to Rule 54(14)(b) of the CCS pension rules. In Rule 54(14)(b) of the CCS pension rules, the phrase "in relation to a government servant" would indicate that the categories of persons listed thereunder, such as wife, husband, judicially separated wife or husband, son or unmarried daughter who has not attained the age of 25 years, adopted son or daughter, etc., are sought to be brought into association with the deceased government servant. The context requires that association or connection of such persons with the deceased government servant must be direct and not remote. The said rule requires that the family member must have a close nexus with the deceased government servant and must have been dependent on him during his lifetime. Therefore, a son or daughter adopted by the widow of a deceased government servant after the death of the government servant could not be included within the definition of family under Rule 54.14b of the CCS pension rules. The family pension was devised as a means to help the dependents of the deceased government servant tide over the crisis and to extend to them some succor. Therefore, the definition of the term family cannot be extended to include those persons who were not even dependents of the government servant at the time of his death. In the present case, the heirs listed under Rule 54.14b of the CCS pension rules are the immediate dependents of the deceased government servant. Therefore, persons who were not dependent on the government servant prior to his death cannot be held to be included in the definition of family under Rule 54.14b of the CCS pension rules. The scope of the benefit of family pension be restricted only to sons or daughters legally adopted by the government servant during his or her lifetime. The definition of family is narrowly worded under the CCS pension rules in the specific context of the entitlement to family pension and in relation to the government servant. Therefore, the word adoption in Rule 54.14b2 of the CCS pension rules in the context of grant of family pension must be restricted to an adoption made by the government servant during his or her lifetime and must not be extended to a case of adoption made by a surviving spouse of the government servant after his or her death. This is because the object of the provision is to lend succor to a son till he attains the age of 25 years or unmarried or widowed or divorced daughter, similarly to the adopted son or unmarried adopted daughter, when such an adoption had been made by the government servant during his or her lifetime. The definition of the word family in relation to a government servant means various categories of persons coming within the nomenclature of the word family, and all persons who would have had a familiar relationship with the government servant during his lifetime. Any other interpretation would lead to abuse of the provision in the matter of grant of family pension. The present case is concerned only with the definition of family under the CCS pension rules. The said definition is a restrictive and specific one and cannot be expanded to take within its sweep all heirs as provided under Hindu law or other personal laws. Therefore, the judgment of the High Court is hereby affirmed.